Ladies and gentlemen, I would like to welcome you from Brussels. I'm happy that at least this way I can take part in the conference organized in Berlin and to contribute a little bit to the discussion about the access to the justice. Access to justice, which I will talk about from the position of the European Data Protection Supervisor, the Data Protection Authority, and taking into consideration the newest developments as far as artificial intelligence is concerned. European Data Protection Supervisor is the supervisory authority of the European Union. We are the data protection authority dealing with European institutions, agencies and bodies. And at the same time, we are the main advisor of the European Union in all the discussions about the new legislations that are going to be passed by the institutions. So today, at the times of the German presidency, the Council of the European Union, it's not surprising that the topics connected with artificial intelligence and also artificial intelligence being used in the criminal justice, in civil justice, in administrative justice, and in the whole jurisprudence is a part of the story. Well, we know that Germany is one of the main strongholds as far as the discussion about the new technologies in law is concerned. As I said, the European Data Protection Supervisor is the supervisory authority of the European Union institutions, bodies and agencies. In our strategy for another 4 years, we said that we want to see and understand how the words operate, but first of all, to foresight what can be the results of that for the future of European Union institutions, but also the whole work of the law and all legislative environment in the European Union. And let me then go to these topics connected with artificial intelligence, which I'm not going to discuss as the general threat to the society or threat to the humanity. All the discussions about singularity and the machines taking over humans, that's something which is not that much interesting for me, because we are at the times where artificial intelligence is already here. Artificial intelligence, which is of course a marketing notion. So this is the notion that I cannot say has one definition. There are some attempts to create the legal definition, although, for example, the European Union, the European Commission, has decided not to do it in the white paper on artificial intelligence, which is right now under discussion in EU institutions. We have some attempts that are right now in the discussion about the recommendation on profiling by Council of Europe, but actually we still see that this is a kind of bag to which we take all the sophisticated tools that exist at the moment and that we want to see in the future. So what then I'm going to talk about? I'm going to talk about only one interesting subject which seems to be quite new for Europe and also quite new in the other parts of the world, although from 2015-16 start to be present in the activities of the law companies on the other side of the Atlantic, and which is dealing with the profiling of judges and profiling of juries, and using the statistical tools which are called sometimes artificial intelligence, but actually they are just predictions done over the statistical data to assess what are our chances to take the winning part in the judgments, in the processing which is going on in the court. And that is a part of the economy of justice, understood as profiling in order to find out what will be the results. So we are not talking about the jurisprudence using artificial intelligence, but jurisprudence being prepared that artificial intelligence is in use around. The thousands of the companies, thousands of entities which are using at the moment different legal tech, law tech solutions are visible on both sides of the Atlantic. But we can say that the things that are visible in Europe, these are rather still legal information retrieval systems. Sometimes it's this different kind of assistance towards the judges and assistant towards the lawyers, while at the same time those that are appearing on the other side of the Atlantic are going to another step, the step where it's not descriptive decision, this is not descriptive analysis, this is the predictive analysis and even prescriptive analysis, which starts to help in the decision process inside the company. Legal tech is of course not the new phenomenon as well. We had different kinds of information retrieval systems, but also the expert systems and systems even requiring the discretionary decisions which have been created so far. They were rather the rule-based systems, but we have the experience in it, and this is something to keep in mind as well when we will be deciding how to legislate in this field. So the predictive systems like Lex Machina, like Lex Predict, try to predict the outcome of the lawsuit. Why the new ones, like for example premonitories, they try to assess which lawyer can win at which proceeding towards which of the judges or the juries, of the members of the juries. The machine analysis of the high number of different judgments, opinions, but also dissenting opinions of the judges, and also the decisions which are taken by the juries of different composition, allows to find some patterns. What is the problem with access to justice with it? Well, of course, it means that this economics starts to decide which cases are taken and which are not taken by the lawyers. You are probably aware of the situation that happened with the use by the courts in the United States, the system which is called Compass. This system, which helped the judges to assess how possible is that the person who is convicted will come back to the crime after that, after the punishment. This system started to be recognized, the race bias. So the decisions about the people of color started to be much different from those who were white. Of course, that was the analysis of the statistics, which said that by definition somebody who is of color should be treated differently than those persons who are white. But this is something that the judges can somehow react on. And now we have the economics put it on the other side of the barricade, I may say. And these are the lawyers who are deciding whose cases they are taking, whose cases they are leaving. And the access to justice to the vulnerable group of people will be definitely the worst. But the judges will not be even able to assess it. And this is this kind of jurisprudence which might be a little bit surprising for us and may show us that we are actually losing the control over what's going on. You probably heard in 2016 the advertisements of one of the law firms in the United States who said that they are employing the first artificial intelligent employee. Well, of course, that was a kind of shortcut that they did because there was no robot that was employed. There was an information system, ROS, based on the IBM solution called Watson, which helped the lawyers to go through the millions of documents, hundreds of databases that may store the information to be used in the insolvency cases as it was in this first company. But actually that was the moment where the lawyers started to know that the decisions can be done with the help of the systems like that, and then they can recognize the system as the not only sophisticated tools, but some kind of the partners in the discussion. Of course, I would say it's a wrong approach. I absolutely agree with Dan Tennant, who said that we don't need a partner. We don't need the partner to discussion. We need the tool. We should not humanize the information system. We should use this information system knowing what the system is doing. So I may say that our approach as those who try to understand how the jurisprudence will look like with this kind of tools, that should help the lawyer, but actually they may limit the access to the justice, drives us back to the meaning of the word jurisprudence. This is not something which I invented. This is not something that is new. This comparison between the word prudence, which is in jurisprudence, and the old meaning of that, which was revealed by Cicero. That's actually the work of the Council of Europe and one of the committees which works for Council of Europe, who drove our attention to the old text from the book, from the Inventione, book 2 of Cicero, who said, what is prudence? Prudence, justice, and fortitude and temperance are the divisions of honesty, and prudence is the knowledge of the things which are good or bad, or neither good nor bad. And its parts are memory, intelligence, and foresight. Memory is the faculty by which we mind recovers the knowledge of things that which have been. Intelligence is that by which it perceives what exists at present, and foresight is that by which anything is seen to be about to happen before it does happens. So we may say that the memory is our works that we had with the expert system, with the rule-based systems in the legal domain. Intelligence is our knowledge on how these tools operate right now, how they are processing the data, including the personal data. And foresight is the ability of the judges, ability of the lawyers, ability of the legislators to assess how these things will change our society in the future. And this is something which I would like to request all the participants of the conference to think about. What are these things that we know and we can recognize do with our society in the future? Because this kind of prudence added to justice will give us the jurisprudence of the future. Thank you very much, and I hope this will be useful for the further discussion about the access to the data, access to the information, and access to justice at the times of digital developments.